In this situation, if you are awaiting availability of an H-1b and it's eventually approved, but you stayed inside the United States beyond your I-94, you were granted on your previous visa, you're not going to be able to change your status to an H-1b. You would have to consular process. When you leave the United States to consular process, you may trigger, if it's been over 180 days that you stay in the United States without status, the 3-year bar of reentry. The 3-year bar of reentry usually states that you cannot come back to the United States, and if you have this great job offer and approved H-1b or other means of coming back to the United States, until you can show that you were married to a U.S. citizen or permanent resident, or have a U.S. citizen or permanent resident spouse or parent who would suffer extreme hardship if you're not allowed to return during that 3-year period. So what do you do when you don't have a qualifying relative for that waiver? You don't have a permanent resident or U.S. citizen spouse or parent. What you may be able to apply for is called an NIV waiver. An NIV waiver stands for a non-immigrant visa waiver. The non-immigrant visa waiver has a different standard of review than the typical inadmissibility waiver for the 3-year or 10-year bar. What the consulate would determine before forwarding the NIV waiver petition on to CIS is 1, what is the risk of harm to society if you were allowed to re-enter the United States prior to your 3-year period that's being barred? 2, how serious was your immigration law violation? So in your situation, how long did you overstay, and were there any extenuating circumstances for the reason why you overstayed? And are those circumstances likely to happen again? Is this repeat behavior? And 3, what is the reason that you need to enter the United States before the 3-year period, if you have the 3-year bar, for instance, as a reason of inadmissibility? So they're going to look at the type of visa that you were approved for. So in this situation, H-1b. So it would be logical to explain why the company needs you, how the U.S. would benefit or the company would benefit from having you and your skills in the United States, and even if it would benefit other U.S. workers. There's no right argument, and it's very fact-specific, so speak to an immigration lawyer about what your chances are in applying for a non-immigrant visa waiver at your consulate interview. Generally, if you're applying to waive unlawful presence for a visitor visa overstay, it's going to be more difficult than necessarily a work visa overstay if you can explain that the circumstances were outside of your control. Again, talk to a lawyer about your odds of approval before going forward. But remember, this does not permanently waive grounds of inadmissibility, such as the 3- and 10-year bar for a green card applicant, where you're only talking about a temporary visa, such as an H-1b, which is called a non-immigrant visa. An immigrant visa, you are showing the permanent intent to stay in the United States on a permanent basis because you are applying for a green card. So this waiver does not apply to applying for a green card. And this is exactly where it gets complicated. The 3-year bar timing, for instance, you may be able to serve that inside the U.S. The 10-year bar timing for an overstay of a year or more cannot be served inside the U.S. So always think long-term when applying for an NIV waiver. How much time is that going to buy you, and what are you going to do eventually when you can no longer apply for another H-1b extension, or your employer wants to sponsor you for a green card and you still don't have a qualifying relative needed for the 10-year bar waiver? This is also a common problem for people who have misrepresented themselves or their work experience or the time at certain companies on NIV applications filed at consulates. This kind of misrepresentation can come back to haunt you at the immigrant visa stage when you're trying to stay permanently in the United States and your H-1b employer wants to go ahead and file for the immigrant visa so you can get your green card based on that same employment. I am an expert in complex family-based immigration cases and have a 98% approval rate for the past 12 years. I am a nationally published immigration author and frequent public speaker on immigration topics. I regularly train other immigration lawyers on complicated marriage and family immigration cases for the American Immigration Lawyers Association, Federal Bar Association, and National Legal Education Providers. I represent clients all over the U.S., traveling to immigration interviews and deportation proceedings. Visit our website, humanrightsattorney.com, for more in-depth information and articles on complex family immigration issues.